Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Lynn Thompson, a Mississippi construction lien law expert. Today's webinar topic is getting paid faster with liens, bonds, and contracts. So without further ado, I would like to introduce the fabulous and wonderful Lynn Thompson.
Hello to everyone. I am Lynn Thompson, and I've been practicing construction law for over 30 years. My practice is based in Mississippi, but I'm also licensed in Georgia and Virginia. I represent owners, prime contractors, subcontractors, and materialmen on all sorts of construction projects, including private commercial projects, industrial projects, public construction at the state and local levels, and also those who build for the federal government. This webinar focuses on Mississippi law. Mississippi has only permitted liens to be filed on private construction projects for about 10 years. So for most of my career, there was no right to a lien on a private project. So it's relatively new in my state. Today, I'll be providing essential but basic information on who has lien rights in Mississippi, what notice requirements apply to have a secure lien, what performance requirements apply to have a secure lien, and what deadlines apply to filing a secure lien. I'll also provide essential but basic information on payment bonds for Mississippi private projects, like who has a claim under the payment bond, what are the notice requirements under a bond, and what is the deadline for an action on the payment bond. You need to know that Mississippi does not allow liens to be filed on public projects or public property. So before undertaking work, you need to know whether the property to which you'll be furnishing labor or materials is it public property or is it private property. The important thing to know, or one of the first important things to know about Mississippi's private lien law, is that you have to know what your position is in relation to the owner. All right. Are you the prime contractor? Are you a subcontractor? Are you a sub-subcontractor? Or do you supply materials to a subcontractor? This affects what you must do to secure your lien right. If you are a prime contractor, meaning you have a direct contractual relationship with the owner, then you have a lien right. You need to be properly licensed in Mississippi, but you don't have to give special notice to the owner. If you are a subcontractor, you have a lien right. If you are a subcontractor, meaning a second tier to the prime, you have a lien right. And if you supply labor or materials to a first tier subcontractor, then you have a lien right. But below that, if you're a materialman or supplier to a second tier subcontractor, you do not have a lien right. So you need to make sure where you are on the pecking order. It's not on here, but architects and engineers and land surveyors also have lien rights, but we're dealing with those that are actually involved in the construction process. So if you're a contractor, a first or second tier subcontractor, or a materialman to a first tier sub, you have a lien right. Now, you have to preserve your capacity to file a lien. You have to give timely notice of labor and materials that are provided. We'll talk more about that. You have to be properly licensed, and this applies to both sides of the contract. Both contracting parties have to be properly licensed. And you have to have made proper payment to lower tier subcontractors. And you must be in substantial compliance with the contract. And this is true at all tiers. Okay, what does this mean about timely notice of labor or materials provided? Well, if you are not the prime contractor, you need to know that you have additional pre-lien notice requirements. Under Mississippi's lien law, it's premised on the notion that the owner is entitled to know who's furnishing labor or materials to the improvement of its property. So if you're not the prime, then you have to give notice to the owner that you are providing labor, materials, or equipment to the property. Now, you see this comment here about the owner request. An owner can request that the prime give it written notice of the subcontractors and suppliers that will be working on the project. And if that request is made, then the prime contractor must give the response in writing within a reasonable time. And if the prime contractor fails to do that, they're going to lose their lien right. Now, the comment about voluntary submission, you can voluntarily provide that information. The prime contractor can. But if you are a subcontractor, a subcontractor, or a materialman supplier to a subcontractor, you've got an additional burden. You're going to have to give notice within 30 days of the first date that you provide labor or materials to the owner. So if you deliver equipment or provide labor on day 1, within 30 days of that date, you have to give notice to the owner of what you're doing. You have to give the name and address and telephone number of who you are. You have to give a brief description of what you're providing. You have to give the name of the project and its location. And you have to give this to the owner, because if you fail to give this in a timely fashion, you will lose your lien right. If you're not making prompt payment to the lower tier contractors, you will lose your lien right. And if you don't substantially perform in accordance with the requirements of the contract, if you're making late deliveries, if you're not keeping up with the schedule, if your deliveries are of non-compliant products, if you haven't substantially performed, you do not have a lien right. So be very careful of all those things. With regard to the licensing, what a lot of people in Mississippi do not know is that you have to have a certificate of responsibility if your contract exceeds $50,000. And if you don't have that certificate of responsibility, your contract is deemed to be null and void. And with respect to the contract, it's legally, it's not enforceable, and neither is your lien right. There's a very easy way to check this. Go to the Mississippi State Board of Contractors website, type in the name of the entity that you're about to contract with, and make sure they've got that license. It doesn't matter if they get it after, they have to have it when they submit a bid to you, and they have to have it when they sign the contract. That is very important. Okay, now read the contract and read the room. This part really deals more with once you're performing on a project, you need to understand who it is that you're dealing with and how carefully you have to watch the what's going on in the project and document what's going on. Okay, so the owner, the project managers, you need to know what your contract requires. It's not enough for just the owner of your company to know. Your project manager, your superintendent, they all need to be read in on what the contract requires. What documentation should be kept? What needs to be submitted with payment applications? When are those payment applications due? Are you being delayed by another contractor? Are you giving all the notices for any recovery you might be entitled to under the contract? And this is important because if you have a lien right, you still have to be able to prove what the amount of the lien is. Having a lien right and using that lien right to successfully secure payment depends on compliance with the contract and making sure you document everything that affects what how the owner or the other contracting party may be liable to you. So get out in front of what it is you need to do. If you are a subcontractor, even if you're a prime contractor, go ahead and get the legal description of the property. You're going to need that to file a proper lien. You're going to need that to make sure that the owner of the property is the owner with whom you've signed a contract. It's going to make a difference, or could make a difference, on who gets notice of the lien. Go ahead and request a copy of the payment bond. Under Mississippi law, if a payment bond exists, you are entitled to get a copy. Why do you need these things in advance, even before a payment dispute arises? Well, you need to know what to do to secure these rights. For instance, under a payment bond, certain information is required to declare a party in default for non-payment. You have to send it to a specific place. You have to give notice of non-payment under the payment bond in some instances, and I'll get to that in a minute. But the point is, you need to be prepared in case you need to do some digging around to be able to file a timely payment bond claim or a timely lien. Okay, so documenting the events, keep up with your daily reports, keep up with project meeting minutes, keep up with scheduling, make the required adjustments to the schedule or request adjustments to a schedule. You need to be very aware of the delivery dates. Advance notice and notice of impact. If you see that you're not being paid or that something is affecting your ability to timely perform your portion of work at the price you agreed to perform it for, you've got to know in the contract if you have to give notice and keep track of that. You have to have very organized internal reporting. You have to keep it up to date. Not only should your field staff be aware of all of this, but your office staff also needs to be aware. You don't have to write nasty letters or ugly letters. Simply write informative and timely letters to make sure that the underlying grounds for what you might need to file a lien for or a payment bond claim for are documented. All right, where are you? Who do you know there? Do you have a legal description of the project property? If you're not familiar with Mississippi, which courthouse will you go to file your lien? You need to know that. What is the filing fee? Who's going to take it there for you? We've had clients from out of state come to Mississippi and perform rather large projects for the first time. And when payment issues arose, it was a scramble for them to figure out who they needed to call and who could get their lien filed in time. So get your relationships established in advance. Okay, with the payment bond, the law in Mississippi tells you who has to have notice and when you have to give it, but the payment bond will control the requirements for that. What are the notice provisions? Under Mississippi law, if you have a payment bond right, if you provide labor, services, or materials to the project and you haven't been paid within 90 days. But if you are a subcontractor, if you are not in privity of contract with the prime, then you've got to give notice to the prime contractor that you haven't been paid. So, for instance, if you're a second-tier subcontractor, you've got to give notice to the prime that you haven't been paid within 90 days of the last date that you provided the labor or materials. If you fail to do that, you lose your payment bond claim under Mississippi law. The claims documentation applies to preserving your underlying claims, same as payment bond as it would on a lien. Okay, you're going to have to watch the clock. This is very important. Under Mississippi law, when you submit a payment application, you are presumed to have been paid within 60 days of when you submitted your payment application. If you don't give notice, the pre-lien notice, you may lose your bond right. You have to file the lien within 90 days of the last date of the labor or services being provided, but you will be presumed to have received payment within 60 days. So you're going to need to calendar the date that you submit the progress payment with a lien waiver. Always calendar that date and make sure your office staff and your field staff are very aware of it. The same 60-day and 90-day requirements apply for final payment lien waivers. You will be presumed to have received payment within 60 days of submission of the payment application, and you can still give a pre-lien notice. You must file the lien within 90 days after the claimant's work is performed, and the lien must be filed in the Chancery Court of the county where the property is located. Now, you have to effect a timely filing of the lien. You have to file it within the proper place within 90 days. You have to give timely notice of the lien to the proper entities. And then you subsequently have to file a timely payment action to enforce that lien. So getting it filed is the first step. The claim of lien must give the legal description of the property. It must state the amount of the lien that is claimed, and it must give a general description of what was provided, the labor, the services, the materials that give rise to the claim for payment. And if the payment action, which is the action that's filed to enforce the lien, is not timely filed within 180 days, then you will lose your lien right. So don't go to the trouble to preserve all this information and then not make file a timely payment action. Also, no later, this is under giving timely notice of lien to proper entities. If you filed a lien within 2 business days after you file it, you must send a correct copy of the claim of lien by either registered mail or certified mail. You can send it also by Federal Express or the United Postal Service, but it has to be overnight delivery to the owner of the property. And if you don't give that statutory notice, then you will lose your lien right. Now, claim on a bond. You have to timely file the action on the payment bond. And under Mississippi law, that is 1 year from the last day that you furnished labor or materials. But remember, you must file notice of non-payment to the prime contractor if you are a second-tier subcontractor or a supplier. And you must file that notice within 90 days of not being paid. If you timely make that notice, you can still file for an action on the payment bond, provided that is within the 1 year. That's all I have on this. I'm open to questions, but
Lynn, you really are incredible. Thank you so much for all this knowledge and everything. I do have a question I wanted to clarify with you. When talking about how long do you have to notify the owner of your lien, and you said 2 days, does that mean it has to be mailed stamped within that 2 days, or it has to be received delivered to the owner within the 2 days?
The statute requires that you send it within 2 days, and you have to send it within 2 business days, either by registered or certified mail or statutory overnight delivery. We typically use Federal Express or UPS, other documented, trackable delivery service.
Okay, but as long as it's sent within that time frame. All right, but thank you so much for clarifying that. I do have another question that came in. It says, do design professionals hired by the property owner have lien rights even though no actual materials or labor were provided?
Yes, they do. Yes, they do. Again, this focuses on the construction portion of it, but certainly professional architectural and engineering services are part of the design process. And as I mentioned, architects, engineers that provide design services, land surveyors providing surveying services, they also have a lien right. And typically their relationship is with the owner. But yes, Mississippi law does provide a lien right for them.
And for those design professionals, they would follow the standard lien deadline laws in effect for like GCs, essentially?
Yes.
Okay, wonderful. Thank you so much. And then another question, if I am a GC and I have done the proper prelim notices, I filed my lien timely, but I'm still not getting paid, therefore I'm unable to pay my subs, I don't have lien rights then?
So, well, under Mississippi law, they do honor a pay if paid or pay when paid. If you've not paid your lower tier subs, say you've received money payment, but for an improper reason you have not paid them, then you lose your lien right. However, if the contract provides that you're only going to pay from funds actually received from the owner, then I think it'd be a stretch to say that you have lost your lien right because you haven't paid your subs. In other words, at least for a very reasonable period of time, everyone is counting on the solvency of the owner to make payment to the prime, and for the prime from there to make payment to the subs and suppliers. So I don't think payment being withheld by the owner so that the prime cannot pay the subs or suppliers will necessarily trigger trigger a loss of the prime's lien right.
Okay, wonderful. Thank you so much. Should that does the paid when paid clause have to be in your initial contract, or is that just like an expected?
No, under Mississippi law, if you're going to have a pay when paid or a pay if paid clause, it must be set forth in the contractual document. It has to be set forth and described as a condition precedent. It is not something that is presumed in Mississippi law. So that does need to be expressly stated in a contract if one of the contracting parties is going to rely on that to say, hey, I don't have to pay you yet because I haven't been paid.
Perfect. Thank you so much for all the clarification and that information. That does seem to be all the questions that have come up. If anyone does think of another question that wasn't addressed, please feel free to reach out and we'll be sure to answer any questions for you. Can you go to the next slide for me, please? Yep, perfect. Thank you so much. Here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Please remember each state has its own unique deadlines and lien laws, so please check it out on our site to better protect yourself if you are working in a neighboring state as well. And then the next slide for me, please. All right, so our next webinar with Lynn is going to be what happens after I file my lien, how do I get paid? That's going to be Thursday, August 28th at 11:30 a.m. Central Standard Time. So please check us out. Go ahead and register for free at sunraynotice.com/education. We'd love to be able to see you guys there. If you don't mind, give us a moment of your time to give us a review. We really do appreciate any feedback you can provide to us. It helps us better ourselves and our webinars for you. And then the next slide, if you don't mind. All right, and with that, that is all we have for you guys today. Thank you so much to everybody who attended. We hope to see you at our next webinar. Lynn, as always, you are incredible. Thank you so much. I hope you all have a beautiful and wonderful sunny day.